Here on this Free to Choose Friday edition of Jimmy at the Crossroads, we want to delve into some of the legal issues as well as the practical issues of regulating big tech and why we need to beware of government intrusion in that space. And I want to start today by talking about the legal dynamics, both about President Trump's executive order yesterday, but also the broader questions about regulating social media platforms and other big tech companies, as we see a growing discussion about the supposed need to do just that. From the legal standpoint, I am pleased to be welcomed by Eugene Volokh, who teaches First Amendment law in a First Amendment amicus brief clinic at UCLA School of Law, where he's also often taught copyright law, criminal law, tort law, and a seminar on firearms regulation policy. He's also the founder, purveyor, editor of The Volokh Conspiracy, a highly trafficked legal blog, one of the leading legal blogs out there today. Professor Eugene Volokh joins us here on this Free to Choose Friday edition of Jimmy at the Crossroads. Professor, welcome to the show. It's such a pleasure to have you on today.
Likewise. Thanks very much for having me.
Thank you for taking the time. So I want to jump in first before we get to the arguments for or against the regulation of big tech, the idea of President Trump's social media executive order yesterday, to the legal basis for where we're at right now, because there's something called Section 230, which President Trump referenced yesterday. We hear that talked about quite a bit, that protects companies like Facebook and Twitter from legal liability for things that are posted on their platforms and what have you. Talk to us a little bit about the lay of the land for regulation of so-called big tech companies right now, Section 230 and otherwise.
Sure. So we talk about regulation, and we're often skeptical about it. I certainly am often skeptical about it. But of course, the entire legal system, including traditional rules about libel, invasion of privacy, breach of contract, and the like, are all about a form of regulation. So the question is almost never whether to have regulation at all. It's what kind of regulation to have. So traditionally, for example, how have newspapers been regulated? Because of the freedom of the press, we don't have requirements that you persuade the government that it's okay to have you publish a newspaper, but you are subject to the threat of liability for defamation, for invasion of privacy, for a few other torts, based on what you publish in your newspaper. If, for example, it's false and damages person's reputation, you could be sued. And that has historically been true with regard to things that you publish that you didn't write. So a letter to the editor, if that's libelous, you, the newspaper publisher, can be sued for that too. So that's one form of regulation, traditionally for newspapers, for other publishers. Now, what about bookstores? Long before the internet, remember, there were these things called bookstores. I don't mean the real bookstores like Amazon.com, where you just push a button and something gets downloaded. You had to go there and look at the shelves, very backward. But there it was. They were big back in the day. What happened if I thought that a book in a bookstore libeled me? In that case, I couldn't just sue the bookstore because nobody expected bookstore owners to have read every word in the book that they carry, the way that newspaper editors were supposed to read everything that they publish. So they were subject to liability as distributors. So they couldn't be sued unless I put them on notice that this was defamatory and explained why that's so. Then they could be sued if they kept it on the shelves. What about a phone company? What if somebody was libeling me through the phone company? Those were treated, one might say, as platforms. They were completely immune from liability. So one question is, what regulatory scheme should there be for internet services? So one example, what about for email services? There was a New York decision in 1999 that said, well, email services are just like phone companies in this respect. You can't hold them liable. But what about something like Facebook, YouTube, and the like? And in Section 230, Congress decided to deregulate those in considerable measure, to say they're going to be regulated like phone companies rather than like, say, bookstores or like newspapers. That was the law. And what that means is if somebody libels me online, on Facebook, let's say, I can sue the person, although maybe I won't get any money from the person. Maybe I can't even track down the person, but I can't sue Facebook.
So what's so fascinating about this is kind of sort of the evolution over time of regulation in this space, because it is new technology in compared to where things were at before, and it's unique. It does seem like social media is unique because what you've got with a platform like Facebook and Twitter, Professor Volek, is this notion that it's public, that you're sharing information and ideas and thoughts and opinions in a public venue, in a public platform, but it's also privately owned and operated. So it's not quite the same as, say, an email or a telephone call or text message, correct?
So that's right, although note, so for example, there was an old telephone case which involved somebody who had on their answering machine an outgoing message, which was libeling someone. So this was a way of using the telephone system to speak publicly. Likewise, I am still on several email lists with hundreds of users where we talk to each other. Or sometimes the dean of the law school sends messages by email to the 1,000+ students in law school. So there is something of a matter of degree, and something perhaps as a matter of kind, a difference in kind between Facebook and email. But in practice, given that most people don't have their Facebook pages actually read by millions of people, the communications on one's Facebook page may not be that different from communication on email discussions.
Now, let's go to what we've seen this week. This has been fascinating. Let's put up pick one. This is a tweet that President Trump put out earlier this week about mail-in ballots, where he basically was saying this is a recipe for fraud. And in California, you have ballots going out to people who are not supposed to be registered voters. And then Twitter added this little note, "Get the facts about mail-in ballots." That prompted President Trump to push back very vocally. Well, then, yesterday, the president put out this tweet in pick two, where he said, and you can notice two different things in this tweet, that one, the first tweet is there in full. The second tweet says this tweet violated the Twitter rules about glorifying violence. However, Twitter has determined that it may be in the public's interest for the tweet to remain accessible, and you can view it, and you can see what he said in a statement that ended, "Any difficulty and we will assume control, but when the looting starts, the shooting starts. Thank you." So that's President Trump being censored by Twitter. And after that happened, and the mail-in ballots happened, that tweet happened, and Twitter had put up that fact-check notice, the president decided to go forward and put forward this social media executive order yesterday. We'll get to the executive order in a moment, but what do you make about the president of the United States being fact-checked by Twitter on that platform and also being censored by Twitter on that platform?
Censored. They didn't block his tweet. Now, it may be that if it wasn't President Trump, they would have blocked this tweet, and then I think we could fault Twitter for that. What they did was they spoke, right? He said something, they said something in response. That's free speech. That's the marketplace of ideas, I think, actually working. Now, his statement about mail-in ballots was actually an opinion. It's a judgment about whether mail-in ballots lead to a large amount of fraud. As best I'm not an expert on this. As best I can tell, there is some fraud with mail-in ballots. Apparently, not a vast amount, but it's a question of debate. This isn't a matter of kind of proven fact about some specific specific thing that may have happened in the past. This is a matter of judgment about how safe or dangerous mail-in ballots are. About the looting starts or shooting starts, that's also a matter of opinion. In some measure, it's a matter of fact. It is true when people loot, some people may shoot at them. Sometimes there'll be fellow looters. Sometimes it will be people defending themselves. Sometimes it'll be police officers. So actually, I think that President Trump was quite accurate in that. I don't think he was glorifying violence. To the extent he was threatening violence in the sense that all law threatens violence, right? If you do this, you'll be arrested. An arrest is a violent act. No justice, no peace is something similar. So this is a matter of his opinions and then Twitter responding with its opinions. I think the Twitter's opinion that this is glorifying violence, I think, is an unsound opinion. But we're having this debate about it. There's no censorship there. Now, there is perhaps blocking some other tweets, but not here.
Well, but here's the thing, though, about the way in which Twitter conducted its responses. Let's go to the first tweet, for example, where the president put up his comments and remarks of his opinion on mail-in ballots. And then Twitter responds by saying, get the facts about mail-in ballots. That's not just responding with counter speech necessarily. One could make the argument that what Twitter's doing is using its power as the platform leader to say, this guy is factually wrong. Come see our list of supposed facts on this. And so it's not necessarily an equal weight conversation of one speech responding to another speech. At least that's where one could argue.
Well, so who says that the First Amendment only protects equal weight conversations? Most conversations are not equal weight conversations. You have more ability to speak than some person somewhere out there. If you get a caller in, I don't know if you have callers on your show, but if you get a caller in, it's not an equal weight conversation between you and the caller. You can cut off the caller can't cut off you, right?
I could cut off you right now.
You could. I hope you don't, because I'm enjoying this conversation.
Don't worry, me too.
But it need not be an equal weight conversation. And in fact, actually, President Trump is not someone who lacks weight, and Twitter doesn't. I do think when they say get the facts, they're actually spinning the facts too. I think what they mean by facts is our judgment about the best state of expert opinion. And you can fault them for that. We are faulting them for that. But this is the way free speech operates. And historically, of course, it may not have been Twitter. It may have been the New York Times. It may have been CNN, who were very powerful and who still are very powerful. So that doesn't bother me, and I don't think it should bother us, except insofar as you could say Twitter is wrong in these things or Twitter is biased in the ways it does this. Sure, criticize them for that, but it's not censorship. On the other hand, sometimes Twitter and Facebook do block actual things. And the suggestion, as I understood it, in the, Twitter's message about when the looting starts, the shooting starts, is that they're only allowing it through because it's President Trump and it's important to know what he's saying. That is something that I think is bad for debate. I do think it's part of Twitter's property rights as a property owner. I don't think anybody has. Certainly people don't have a First Amendment right to use private property like Twitter, but I don't think it's good for debate that Twitter would shut off statements like, by ordinary people, when the looting starts, the shooting starts.
Again, we're talking with UCLA School of Law professor Eugene Volokh, also the purveyor of the highly trafficked, highly regarded Volokh Conspiracy Legal blog. I want to play a couple of clips of President Trump and get your reaction from the legal standpoint. In Cut 8 yesterday, the president listed out some of his grievances against social media platforms, and I'd love to get your reaction to this. So let's go to Cut 8. This is President Trump yesterday again announcing his social media executive orders.
They've had unchecked power to censor, restrict, edit, shape, hide, alter virtually any form of communication between private citizens or large public audiences. There's no precedent in American history for so small a number of corporations to control so large a sphere of human interaction, and that includes individual people controlling vast amounts of territory, and we can't allow that to happen, especially when they go about doing what they're doing, because they're doing things incorrectly. They have points of view, and if we go by that, it's actually amazing that there was a success in 2016, but we can't let this continue to happen. It's very, very unfair.
So I want to get your reaction, Professor Volokh, to President Trump's comments there in terms of making the case for why some change in the dynamics of social media is appropriate, but for you, from the legal standpoint.
Well, so I think he's making a criticism that it traditionally had been made from the left, but, maybe the left is right on this, maybe not, of private power. That when private entities have a great deal of control over what is said, that is bad for democracy. That's a standard criticism and plausible, although, again, maybe government attempts to control that private power are even worse for democracy. Historically, that's been said about newspapers, because even though newspapers never had the reach of Twitter and Facebook, generally speaking, never had the market share, within particular cities they may have. There were a lot of cities, there were one newspaper towns where basically the newspaper got to control a great deal of the debate. And people thought that maybe unfairly, and maybe in ways that influenced elections. Newspapers were trying to influence elections in many ways. So that's his criticism. Now, what can he do about this? Well, remember, he's the president. He's not the Congress. He doesn't make the laws. Section 230 is out there, and Section 230 says that Twitter, Facebook, and the like are entitled to be free from liability for things that their users post, even if they edit, even if they exclude certain things or delete certain things. That was a deliberate choice by Congress. Congress wanted that because they wanted these services to protect users from offensive material and the like. So that's the law. Also, the law is there is no federal statute that requires viewpoint neutrality by platforms. So President Trump can't change Section 230. President Trump can't enact this new law. Now, in this order, he does a few things. He asks Department of Commerce to ask the Federal Communications Commission to interpret Section 230 to kind of push the platforms towards viewpoint neutrality. I don't think that'll happen. I'm not sure FCC even has jurisdiction over these issues. But even if it does, I doubt that the FCC will actually interpret Section 230 as limiting platforms' power to edit, because Section 230 is all about giving platform power to edit. Another thing that he says is that federal agencies should study where they spend federal advertising dollars, and if they're doing it on platforms that discriminate based on viewpoint, and should discuss whether they could move that advertising to other places. That's something he might be able to do by executive order. It'll take a while, but beyond that, I'm not sure that federal government has that many advertising dollars it's spending on Facebook and Twitter that you can use as leverage this way. And the other factor that's important is Facebook and Twitter routinely engage in viewpoint discrimination that people like. Most people like. And that is they deliberately try to block and delete pro-terrorist propaganda. And not just constitutionally unprotected. A lot of pro-terrorist propaganda is constitutionally protected, even though it's evil, but it's protected. So if you really want to if you really want to pressure these platforms to be viewpoint neutral, you'd have to give up that function, which, as I understand it, administrations of both parties have long actually supported, and the public generally supports. So it's not clear to me that really viewpoint neutrality is something that's going to be politically feasible to insist on. But in any case, President Trump can't really do that. It would take a congressional act to try to do that. Even then, it may be that the platforms have a First Amendment right to edit this way. They certainly have a First Amendment right to flag things as supposedly false, but it's an interesting question whether they have a First Amendment right to block things they don't like. It's an interesting question, but at least Congress could, in principle, enact such a viewpoint neutrality common carrier type statute for platforms like for telephone companies or some cable operators or the like. But President Trump can't do that.
Well, here's one of the things that's deeply concerning to me from a philosophical level about this kind of approach that President Trump is wanting to take, Professor Eugene Volokh, and that is that when we have the government get involved in regulating speech aspects of these social media companies, that could lead to the federal government starting to make determinations itself about censoring speech or not censoring certain types of speech, which then gets into a more difficult situation in terms of the First Amendment. It actually starts to kick in, I think, if there is no longer the ability for these social media companies to make their own determinations as to what should or should not be blocked. If you have the federal government getting involved, then I think that opens up a dangerous can of worms from a constitutional and individual liberty standpoint.
Well, it's complicated. The precedents are not completely clear. So let's assume that Congress, and again, it can't be the president, it has to be Congress. Congress is who makes the laws. Let's assume that Congress says platforms, when it comes to deciding whether to host your web page or host your Facebook page or not, must be viewpoint neutral, or perhaps even must be content neutral. They have to be like the phone company, which can't just say, well, we think you're a Nazi or we think you're a communist, so we're just going to cut off your phone service. So let's assume Congress enacts that kind of law. I'm not sure that law will be a step towards the government then deciding which speech to allow and which not to allow. On its face, the law and in practical application will say these private entities have to allow all speech, at least maybe setting aside constitutionally unprotected speech like true threats of violence. So that's so I don't think it would be somehow inherently bad because it allows government censorship power. But the interesting question is, to what extent can the companies say, we're like newspapers who have the right to decide we want to not publish some op-ed. The Supreme Court held in 1974 that a law mandating that newspapers publish responses to criticism of candidates, that was unconstitutional because it interfered with their editorial discretion. So Twitter, Facebook, and such may say, well, we should be like newspapers. But in 1994, the Supreme Court said in a case called Turner Broadcasting v. FCC that it was okay for the government to say cable system operators have to carry cable channels, have to carry broadcast channels as cable channels, even if they don't want to. And that didn't interfere with editorial discretion because as cable operators, they don't have the same rights to editorial discretion. And the Supreme Court upheld that by a 5-4 vote. So the legal question would be whether these platforms are more like newspapers, again, not as to their own speech, but as to decisions about whom to include or exclude, or more like cable operators. But again, that only really comes up once you have this kind of common carrier or viewpoint neutrality mandate, and it takes congressional action, not just an executive order to do that.
What do you make, Professor Volokh, in just a few minutes left with you, appreciate your time today here on Jimmy at the Crossroads. What do you make of the argument that these tech platforms are monopolies in effect, and therefore they should be regulated as such because they are so big, they are so powerful, they are so intrusive, so we should either break them up or we should treat them as utilities or take other steps regulatory-wise to address this notion that they are monopolies and thereby protect the individuals who use these platforms or are customers of different big tech companies?
Well, I'm not an expert on monopoly law or monopoly policy. As it happens, actually, the other Professor Volokh, my brother, who teaches at Emory, is. But
Maybe
I'm not.
Get a dual Volokh conversation then about that. That would be fun.
There you go.
Go on.
I can't speak with great confidence to this. My understanding is that there's nothing by way of illegal monopoly about Facebook or Twitter and the like. It's not like they deliberately monopolized the markets in particular ways. They just happened to create a service that a lot of people want to use. And because of these so-called network effects, because a service is more valuable to users if it has a lot of users, it tends to snowball and become very, very powerful. So the real question here isn't of technical details of antitrust law, but more in a sense of political theory and political practice, which is whether you think that once a company gets so big and so powerful that it can help sway elections in a very major way. I mean, all companies may in some measure, but in a major way, that's something that's bad for democracy, and there should be more democratic control. Maybe not to say, well, you have to say this rather than that, but perhaps to make sure that they don't exclude certain voices and the like. That's a very interesting and difficult question. And you could say, no, private property is the really important thing. And if they're using their private property, they should be free to do that. You could say, well, no, making sure that there isn't undue control, undue power, private or public, is the important thing. You could say, in theory, it's okay to regulate, but in practice, they're actually not that influential, although I suspect they probably are. Or you could say, it's in theory maybe okay to regulate them, but in practice, we think the government will do more harm than good, as it does in a lot of situations where it tries to regulate. So these are interesting questions. I don't think the answer is obviously one thing or the other. I think this is a reasonable matter in which people could dispute. But again, very little authority here for the president as opposed to for the Congress.
Final question for you, Professor Volokh. When it comes to the circumstances of the law, it seems to me that when people are concerned about that, say, a Twitter or Facebook is not applying their terms of service and their rules consistently, say they are blocking certain speech versus other speech, and you can make the argument potentially that comparatively they are on the same plane and you should block both if you're going to block the one, or you should block neither. I guess what I'm getting at is the court system. Is that the way to settle these sorts of disputes? If you think that Facebook or Twitter or YouTube is inconsistently applying the rules, that maybe that's the vehicle to do it, as opposed to some sort of a new regulatory regime where you have bureaucrats getting involved, or something along the lines of what President Trump is suggesting. Could that be the ticket?
Well, so under current law, it's just not illegal for them to be unfair in this way. Just like the New York Times may say, oh, the news that's fit to print. But people say, well, wait a minute, why are you not printing that and printing this? Well, They may say they're objective, but they're human beings. Human beings are never perfectly objective when they're applying vague editorial standards. And there may be some discrimination there. That's not illegal. In fact, for the New York Times, it's clearly their First Amendment right. So under current law, there's just nothing wrong with Twitter doing that. Nothing illegal about Twitter being biased if it is biased. Now, the question is, what if there is a law enacted? Who should enforce it? And yes, I think that having it be done through some executive branch employees, some administrative judges in some department, I don't think that would be constitutional. I don't think that would be wise. I think it would have to be done through the court system, which has important protections for its independence, which has juries as an option. For all the faults that juries have, that's the way we have our system operating, and that it's something that would need to be done through the court system with all the inefficiencies and expenses and delays that the court system has. Now, of course, there's one other option, which is to have a statute that requires transparency, that requires Twitter to at least publish all of its decisions. Twitter is an example here, anybody else. Publish all of its decisions. It can't then be sued for a decision, but it has to explain what it's doing, and it has to do it truthfully. Maybe it could be sued if there's real evidence that it's untruthful, although that would have posed own problems. And then the rest of us can at least see and can at least know what's happening. That's possible. Again, though, that would require a totally new statute.
Sure. Well, we have seen some different social media lawsuits that have not been successful for those trying to challenge, say, Twitter. For example, there's a Prager University case in that regard that have not necessarily been so successful in making sorts of arguments along those lines. But my view would be if you could set up a system where the courts can suss it out, I agree with you that it's better than, say, a bureaucrat at the FCC or some other government agency making those sorts of determinations. Professor Eugene Volokh of the UCLA School of Law, thanks so much for taking your time today to join us. I really appreciate the conversation.
Thanks so much for having me. I very much enjoyed it.
Thank you. Same here. Again, Professor Eugene Volokh of the UCLA School of Law. Check out his blog at Reason.com. The Volokh Conspiracy. We had Professor Ilya Somin on a couple days ago. Professor Somin is one of the bloggers at the Volokh Conspiracy. He's a contributor there. Great place to go for interesting legal analysis. Appreciate the conversation with Eugene Volokh. You just watched a clip from Jimmy at the Crossroads. Don't miss more engaging, intelligent talk. Subscribe to the Jimmy at the Crossroads YouTube channel today. You want to catch our live show. And I love your support.
I got Jimmy at the Crossroads, making sense out of no sense. Yeah.